Well, good afternoon. We're here to work through our bullying, harassment, and conflict seminar. My name's Elaine McCormick. I have been practicing law for over 30 years and fascinated with strata law for that entire time. And I am very happy to talk to you about bullying, harassment, and conflict and what we can do about it in a strata corporation. Many thanks to this week's sponsor, Power Strata Systems, Inc., dealing with strata management software. And many thanks to CHOA for putting on this seminar. Thank you, Tony and Daryl. We have a format today where we're going to try to end at about 45 minutes in the hopes that you can enjoy some of your lunch without the seminar, but we'll see exactly how we go. I'm going to go through some slides first, and then we hopefully will have time to field some questions. With respect to participation today, we are keeping it really clean in the respect of the Personal Information Protection Act. When you do ask questions in the chat line, we're going to take out any sort of specifics or identifying information, and we'll talk about concepts as opposed to particular circumstances. Hopefully that will be of assistance to you. You can, of course, decide later on that you might want to hire a lawyer to deal with your particular issue. With respect to harassment and bullying in general, it's something that has been dealt with from a legal basis more in the employment context. Bullying and harassment are recognized in the employment context, including verbal aggression, personal attacks, and other intimidating or humiliating behaviors. Workplaces often have policies and enforce those policies. This is common in strata law, really, that we take concepts that are better thought out in other areas of the law and we apply them to strata corporations and to the unique nature of the Strata Property Act and the corporate setup of a strata corporation. So we work through this consistently with legal concepts, and harassment and bullying is the latest, I believe, one of these concepts that we are converting into how it's going to play out in a strata context. Another example of this is Personal Information Protection Act, for instance. Many strata corporations have privacy policies that they've put into their bylaws. We are now looking at harassment and bullying, or anti-harassment and anti-bullying bylaws that we're now putting in as well, and using those concepts in a way that works for strata corporations. So in the strata context, bullying and harassment are behaviors likely to fuel disputes and litigation. Strata councils and property managers are often the target. So we are looking at, let's say, strata managers. This is a combination, really, because we're looking at it in the employment context as well as the strata context when you're looking at strata managers. For strata council members, you're looking at it in the context of a volunteer position. So those groups require a specific consideration when you're dealing with the bylaws. As many of you know, you've probably seen many disputes play out for stratas. They often involve some combination of owners and tenants, or council members, occupants, service providers, employees of the strata. So again, we're looking at a strata context there, including live-in caretakers, and strata managers who are working basically as contractors for the strata corporation. They're employed by another entity generally, but they do have this employment context and strata context that they're working through. Those who are vulnerable are sometimes bullied in a strata. community. And there should be efforts of council to recognize this and try to ameliorate these behaviors. So we often see community minorities, people that are a minority in the community, language barriers, or the elderly being subject to intimidation. Common actions include proxy farming. You'll see in strata corporations sometimes the elderly giving their proxy to more than one person, people banging on their doors and insisting on receiving a proxy. We see intimidation of minorities into positions of submission. And we also hear for many different people the fear of retaliation in the strata corporation. If they make a request or do something, they fear that there's going to be retaliation either from an owner or certain council members, or perhaps all of council. In considering conflict, one of the things to consider is the stages of conflict. It's important to think about this because I think that many of us grew up in a time and in a way where maybe we like to avoid conflict, at least in what we consider to be our personal lives, which means that the stages of conflict are generally not addressed and not worked through. So when you look at stages of conflict, you're looking at a latent stage where people probably are not aware that there's a potential for conflict. There's an emergence perceived conflict at some stage. People are understanding that their interests perhaps are different than the interests of other people, or they're not feeling respected. There's felt conflict, and then an escalation of it. So there is conflict that the council's hearing about, potentially between two owners. Everybody knows about it. Sometimes there's a stalemate. What we want to see is to work through the conflict with de-escalation so that there is some type of negotiations, potentially a dispute settlement, and then the aftermath of conflict. But what we see often is that the stages of conflict remain at the escalation stage or the stalemate stage. And so it is important for the council, for instance, to be able to work through a conflict. Doing nothing often, if there is a dispute between two owners that has anything to do with the bylaws, doing nothing is not the way to go, because what you end up in is a constant escalation and a constant stalemate. And this can even happen if the strata corporation or an owner take the matter to the Civil Resolution Tribunal. Because the Civil Resolution Tribunal, depending on what is pled in front of them, the dispute notice and so on, may not actually resolve the actual conflict that's driving the escalation. It may at times, but oftentimes the conflict is greater than the decision made at the Civil Resolution Tribunal. So it's important to use other internal mechanisms within the strata corporation, also potentially mediation or negotiations, and these other skills we're going to talk about, to work through and potentially end up with a dispute settlement or a greater understanding. Do you have thoughts on this, Tony?
No, I was just thinking as you were talking, Elaine, though, that what we see is these escalations start to get documented in discussions between people, and that's where it takes on a whole other realm of conflict.
It does take on a whole nother realm of conflict, and those communications, for instance, between council can actually be a fuel of the conflict. They can actually come up in court as relevant documents. And so if you are working through a process in making a decision, let's say dealing with bylaw enforcement, It's important to work through the process and document those investigations that you need to document. But what often happens is that council members, for instance, share their frustration in writing with each other. And it could be a valid frustration as a human being, because let's say you have someone who's made an awful lot of complaints, but each complaint needs to be considered on its own, and we shouldn't treat certain people as the other, in the sense of we need to deal with the complaint, not the personality. Is that where you're going with this a little bit, Tony?
Pretty much. But that cascade of conflicts coming from every angle that creates so many problems. I think for strata councils, though, and property managers, I think we're going to visit the declaration of people who are becoming more vexatious, much more so in the future. Individuals who demand every document, who demand every record, all communications, are constantly filing complaints and harassment, and using everything that they can in their toolbox to terrorize their strata corporations and councils and their fellow owners at the same time. It really creates so much conflict, but I think we're going to see a movement that's going to take us into more vexatious challenges in the courts.
The vexatious challenges through the courts are, I believe, definitely increasing. We certainly, after selling somebody's property several years ago, we've been involved in a series of decisions of the court whereby the Court of Appeal finally dismissed a litigation simply based on the fact that the person had their strata lot sold through order for sale proceedings. That just got dismissed a month ago or so. We're also looking at the court really, I think, being overworked and having a difficulty working through these types of problems. And it is possible in these types of problems that the court system might lean towards document disclosure. We've seen that recently in our office, where even if someone starts a petition, the court proceedings have now changed, where if someone starts a petition, let's say for an administrator to be appointed, they may be able to gain access to communication between individual council members about issues. And so we're really looking at the strata corporation streamlining its process, streamlining its communication, even between individual council members, and running a really clean shop. You can't ever control what other people do. And so I think that if you're working as a council member, volunteering, you're a strata manager, you can do the best you can. You also have to accept that we cannot control others. So it could be that you get involved in a situation where someone's vexatious. And so these tips aren't meant to blame council members, or say that you could have done better and that the only reason you'll have conflict is because you didn't do one of these things. However, I do believe we can sometimes influence the behavior of others. And so we're going to talk about those things that can be done that may assist in lessening the possibility that the strata corporation is going to be in an unresolvable conflict. One of the things that happens is communication breakdown. So there's miscommunication, lack of communication, or just what I will call communication exhaustion. And that lends itself to cases where, like Tony says, somebody's complaining about everything. They want every document in the strata. They have concerns about every decision being made. So one of the things is to set reasonable expectations of busy strata managers and councils. And part of anti-bullying, anti-harassment bylaws that we have drafted sometimes set out these reasonable expectations of communication. And so if someone has a unreasonable expectation of the time frame or the decision-making process, it's not going to help. It often helps too if this is a standard process and it is in the bylaws. So the person who is communicating with the strata doesn't feel like they're being singled out necessarily. The strata corporation can say, this is our standard process. And so those types of bylaws can be very helpful. Same day responses for strata managers, particularly on a substantive matter, are probably unrealistic in this day and age. Having a council that has to meet more than once a month, unless there's a special matter ongoing, is also likely unrealistic. So setting realistic lines of communication and timing for responses, even if this is something that needs to be dealt with through the bylaws, is useful and gives people an ability to understand what they can expect. Lines of communication are just so important. I believe that a lot of the disputes that I've worked to resolve over the years probably happened because instead of let's say, a bylaw complaint going to council and council making the decision about it, there is a confrontation between a council member or someone else and an owner on common property. And so that's something that happened a lot in the past, but it's a very informal way of dealing with bylaw enforcement. And I find that people are very offended when they're going about their daily business and they are confronted on common property. It's not something that I would generally recommend doing. And when you look at the flip side of that, if you have those lines of communication, as a council member, you don't want to be confronted on common property either. When you're going into the parkade and going to your car to get to work, that's not an appropriate time for a owner to accost you and to tell you how bad a job the council's doing, or give you some information about the strata necessarily. How do you feel about that, Tony?
No, I agree. I agree. It's not um, when individuals get personally harassed or attacked, it's very frustrating for them, and then they lash out in return. Or if they're attacking a council member, they lash out in return. And we see it in a variety of tactics, though, right? People find that their insurance claims, because there's been a leak, the council's decided we don't want to increase our deductible, so we're just going to block this and force all the owners to have insurance claimed on their units, which then becomes this horrific three-ring circus because it shouldn't have happened in the first place, or they ignore real complaints about problems. Sewer backups in units, when that happens, it's an indication you have a problem in your building. Usually might be localized to the unit, but it's often a building problem or a ground problem. If it's only one person and you're targeting that person, strata council will ignore it. They might have 2 or 3 sewer backups before they finally create a big enough crisis for the corporation. People's habits are the same, right? We all have the same tendencies and the same behavior patterns, but dealing with issues like that quickly just takes them off of the conflict level, and takes them off the frustration level. And it's I kind of amazed sometimes how far people will go when they're really pushed. So it's don't target individuals.
I really like those comments, Tony, and I like the examples you gave because, of course, there are situations where you do need to act quickly in a strata, the more emergency type situations. but only to the extent that it is an emergency that you're dealing with, for instance, right? So it could be that an individual council member is dealing with a leak and dealing with phoning emergency services or notifying the strata management's emergency services. However, moving forward and making a decision about the insurance deductible and all of that is something that is a council issue. And so dealing with those things that you really do need to deal with in the moment. And a lot of things really don't need to be dealt with in the moment. So this also relates to poor decision making, unilateral decision making. We see sometimes council presidents taking on too much. They're doing a lot of work, but they're also unilaterally sometimes making the decision, or it could be other council members. One of the things that plays out, I think, a fair amount in the court system, and Tony alluded to it, but also at the Civil Resolution Tribunal and the Human Rights Tribunal, is decision exhaustion regarding one owner. So it's really hard to look at that request from that particular owner in a new light and to work through that request. We have at times even drafted bylaws that set out how many resources will be put towards one person's requests. And of course, it's not pointed at one person in the bylaws, but decision exhaustion and resource exhaustion are real, and they can contribute to poor decision making, because the Civil Resolution Tribunal, the court, the Human Rights Tribunal is not going to look at necessarily at the fact that the person has made 30 complaints. They're going to look at the complaint that's before them and make a decision about whether or not, for instance, in Human Rights Tribunal, you've accommodated the person's physical disability. And so we have to guard against decision exhaustion as best we can. Overly strict governance, so not every potential bylaw infraction needs to result in a fine, needs to result in full enforcement. Casual governance, where there is the idea that maybe because, let's say, we're in a strata with few strata lots, we don't really need to follow the Strata Property Act. That usually goes well until it really doesn't go well. Unclear decisions or just lack of decisions allow us to not move through that stages of conflict chart that we looked at. Favoritism, if there is the idea that council and the friends of council members are treated differently. Conflict, exclusion by established community leaders, and just the concept of a dictator president of council. So we are looking at follow the Strata Property Act decision-making processes. And I think if you're very interested in the process and you work through a process, whether it's at an annual general meeting, a special general meeting, or a council meeting, and you are fulfilling your function through that process, you really create sometimes a environment of comfort for others. And so one of the things I see, for instance, is when a CHOA member chairs an annual or general meeting, or another experienced chair, you really have someone that's fairly working through the process, interested in the process, not invested necessarily in the outcome. And you really can have a different feel to that meeting and a feeling that you're a community and you're working through it. And it is okay to have different views. Do you have any comments about chairing a meeting, Tony, an annual general meeting or special general meeting?
It's funny you should mention that, because I have really learned to like electronic meetings, because there are no secret ballots, and they have solved a problem for us. Individuals who abuse their strata corporations or who take control of strata councils, who collect 50% or so of the proxies so they can control everything, cannot do that when you are doing electronic meetings. In electronic meetings, you can identify whether it's in person or by proxy, how each one has voted. And so if you're into an in-person meeting with no electronic option, they can walk in with 55 proxies, vote the way they want, regardless of the impact on the corporation. They will call for a secret ballot and they will simply abuse and control the system. So it's one of the real benefits that I like about electronic meetings. Downside of electronic meetings is I don't find them great community builders. But to be perfectly honest, when any of our staff go to an in-person meeting, it's usually because there's conflict. They're not good community building opportunities anyhow. It's about getting the conflict off the table and moving forward. So, I encourage strata corporations to have a lot more collective gatherings and meetings that don't have the stress of general meetings for community building. Using electronic meetings can really help to ferret out the individuals who are predominating the outcomes because they hold so many proxies.
So as we move forward and the use of technology changes and people set things up differently, I know of some managers, for instance, that use polling, and so they don't have the same accountability with respect to how people are voting, and so they do not necessarily it's not necessarily known how each unit votes because they're using the polling. Polling can mean different things, but they're using a polling function in Zoom. And so that's interesting that you feel that there is a benefit at times for, let's say, somebody holding 50 proxies to have some accountability about how they vote. So we're losing something maybe by using certain technology.
I actually don't think polling is a valid method of voting because you can't identify who votes. Otherwise, what would be the point of registering individuals either with a virtual voting card by their identity or a voting card? I don't believe polling is a valid method of use of calculating votes. And and for the very reason, as the chairperson, you simply can't identify who voted. It's not how they voted, but who voted. At least if you're in an in-person meeting and John Smith stands up with 55 proxies, we can identify John Smith has 55 proxies and they were voted. Or if paper ballots were issued, you have an audit trail. If you're polling, it's very easy to lose control of what's taking place and very difficult to understand who actually voted.
Very interesting. So fueling conflict and extinguishing that conflict. We have one of the things that I see quite often with individual owners in conflict with their strata, and obviously not always, but often there's a mental health crisis, a stress, a physical crisis, like health crisis, or something else they're dealing with in their personal life. Sometimes it's an unrelated issue. It's important for a strata corporation to consider whether, for instance, there could be a human rights code issue. The strata corporation must maintain some curiosity that way. The council must look into it even if the person doesn't say, hi, I have a human rights code issue. But if there's reason to believe that, the strata council may have to consider how to bring that up with the owner or the tenant or the occupant. It's important to consider guide dog and service dog acts. So it could be that even if someone does not need an animal through the human rights code, there could be another method upon which they could request one. To consider the Mental Health Act and when there could be help from government services, and to consider using some measured empathy in addressing an individual. And again, that goes back to treating an individual as part of the community instead of the other. Only that person knows what has occurred in their life, and how they react may be a combination of all their life experiences that none of us could necessarily share. Conflict is fueled by disrespect, often inflammatory language, discriminatory language, and unrealistic expectations. There are times when you just have individuals that will not accept a decision made by the council or by the strata corporation owners. There's divisive issues or factional divisions, and it's important for that not to create decision paralysis. We see this in communities, for instance, dealing with repair and maintenance issues. We also see personality conflicts. Consequences include owners feeling unsafe at meetings, the proxy farming that Tony's talked about, difficulty attracting council members and maybe the inability to form a council as a result, inability to address strata decisions, increasing strata fees because you're dealing with litigation and disputes, and claims at the Civil Resolution Tribunal, the Supreme Court of British Columbia, or potentially Human Rights Tribunal. We see sometimes communication breakdown that we've talked about. If that occurs, minutes often show dysfunction in a strata, and that discourages sales. It decreases both the property value and the opportunity to sell individual strata lots. There's could be penalties and sanctions dealing with workplace, WorkSafe BC. We have the possibility of outside decision makers weighing in on strata decisions, including the costly appointment of an administrator to replace council or perform all or some of the duties of council. It's important to consider Section 31 of the Strata Property Act, where each council member must act honestly and in good faith and exercise reasonable care and diligence. We have a slide on fair, consistent, and correct bylaw enforcement. And Tony, I think this is one of the issues we've dealt with most in CHOA seminars probably, is following through with Section 135 in a fair way and coming up with a decision on those bylaw matters that require a decision. Although there are some abilities to deal with certain bylaw violations in potentially without obviously fining or stopping someone from using a recreational facility or providing an order that they pay for the cost of a contravention. There are other methods of dealing with bylaw contraventions, and I'm wondering if you want to talk about how you feel about the use of things like warning letters or discussing things that don't necessarily result in a fine, for instance.
Well, bylaw enforcement is about remedying behavior. It's not about penalizing people. So, and we've seen that both through the courts and the CRT, where fines and penalties are dismissed because all the strata is doing is just simply fining it and using it as a revenue source, or attempting to, and then the party turns around to challenge it eventually. And it's about changing, amending, or correcting behavior. So there are always unusual circumstances that arise. Bylaws being enforced unfairly is very common, where and it's not about changing the way the bylaw is and misinterpreting. It's about enforcing a bylaw against one person, but not enforcing it against another person. Instant conflict. You've just poured some gas on it, and it's now going to be a greater problem. The other challenge, and again, this is a common complaint, strata council members or strata councils will appoint one person as the bylaw officer or as the bylaw person. There is no such position. Council cannot delegate the enforcement of bylaws or rules to any other party. They have to make decisions. They have to decide on what the outcome is. But individuals in those positions often make up bylaws or rules, or they'll call them regulations, that don't even exist in the strata corporation. So, for individual owners, challenge it, don't be bullied, and just simply request what the outcome is going to be when you're dealing with that. And I think that a key function that we see currently is the individuals who really want to harass strata councils constantly request hearings. They're trying to basically exhaust or tire their strata corporation into capitulating to whatever they want. Strata councils now are starting to plan a little more cleverly. We'll dedicate the first 15 minutes or first half hour of all of our council meetings once a month to accommodate any hearing requests. Just please notify us in writing prior to. We don't have to wait 30 days. We're trying to be amenable, and it kind of brings that to an end. That's one of the benefits when that occurs. But not all councils meet every month. So, therein lies another part of the challenge that we all have. Not forgetting council members are volunteers, right? They are just like every other owner who've taken on the yoke of doing the work for the corporation and the investment. So it's really unfortunate when council members become the target of individuals that harass. And it's also just as unfortunate when council members or a council member targets an individual with bylaws unfairly or that don't even exist.
I think that's so important. And one of the things I have done probably for 2 decades is create bylaws that deal with resources. They deal with the time and money of the strata and put some limits on what the strata corporation is going to do with respect to hearings and so on. Of course, you need to consider specific, like the bylaw needs to have some flexibility, but you don't want to be in a situation where 2 hours of the first 2 hours of every monthly meeting involve dealing with the disputes of one owner, for instance, in a 100-unit strata. One of the other things that fuel conflict is a strata Facebook page, and these Facebook pages or other type of social media are often loosely related with the strata corporation. And so the strata corporation needs to really consider what's on these pages or websites, and what is appropriate. Are they giving notices? Are they giving something else? Do you even really need them? Clear and civil communication process is so important, including following the hearing process under section 34.1 or providing an appropriate hearing process under bylaw enforcement. Also, council members, I believe, tend to get pushed more than they should about making a decision. Yes, there are time frames in which you need to make a decision, but more often than not, sometimes there is the concept that you need to answer this email at 1 a.m. in the morning, the concept of feeling pushed because people want to make alterations to their unit and so on. And oftentimes these time frames are not required under the Act to be followed. These things potentially are not really an emergency, and council often makes poor decisions as a result. When we're looking at anti-bullying, anti-harassment, generally the mechanism for a strata corporation to be able to have an enforcement process with owners, tenants, and occupants, it's not through a policy, it's through the bylaws. And so we look at anti-bullying and anti-harassment in the strata context, generally by creating bylaws, identifying clear expectations of behavior, channels and types of communication that are acceptable, but also within the confines of the Act. For instance, a council member can be served with legal process under the Act, so we have to be careful not to cut off lines of communication that are legislated through the Act. Setting standards that council must maintain to ensure communication is a two-way stream. These bylaws should consider WorkSafe BC requirements and what is appropriate to dealing with that. And council must be prepared to not only have these bylaws, but enforce these bylaws. I sometimes get calls saying, this is a matter between two owners and we really don't want to deal with it. And oftentimes it's just not the case. the matters between those two owners may really fit within either the standard bylaws or anti-bullying, anti-harassment bylaws. And so we look at the concept of nuisance, which is unreasonable interference with use and enjoyment of land. It is in the standard schedule of bylaws, and it is slightly different than the concept of anti-harassment, anti-bullying. And yet, I do not believe a strata corporation is creating more work by having an anti-bullying, anti-harassment bylaw, because they're going to have to deal with those same behaviors through the very traditional and perhaps less helpful lens of the common law idea of nuisance that's been legislated into the standard schedule of bylaws. So if you're thinking, well, maybe we shouldn't put in an anti-harassment, anti-bullying bylaw because it's going to create more work, that may not be the case. You're going to have to deal with these issues between owners and owners, owners and tenants, a council member and an owner in any case. It is helpful sometimes to hold information meetings. Information meetings can lend themselves to a more relaxed and fulsome discussion where people are not making a final decision. It's important, any meeting that you hold, to not impose personal agendas. So I believe that the person chairing the meeting should not be the one necessarily. If there's a big issue in front of the strata, the person chairing the meeting should not be the one necessarily making the presentation about that issue or being the one that's pro or con a certain outcome. It is much more successful for the chair to be able to speak on an issue from a procedural basis, listen to all sides, make sure everybody has an ability to talk. And that's one of many reasons why I think hiring an outside experienced chair creates a whole different feel to the meeting and allows participants to be heard and perhaps accept a decision even if they're not successful. We look at hearings before council and the very strict deadlines in which council must hold the hearing, but also, even more importantly, provide a decision. And holding those hearings in a respectful manner is so important. If you have one council member that just feels really strongly about the issue, has a personal issue with the owner, for instance, that's requested the hearing, it could be in their best interest and the best interest of the council that they just do not attend that hearing. We have tips for holding a council hearing, and I did see a quick question through the chat. Yes, these slides will be made available to you after. So we have tips for holding a council hearing, including having a neutral location, or potentially you could hold it online and so on. And so normalizing that you're dealing with something that's awkward and everyone feels a little awkward. Even those types of things, you are creating a sense of community, you're creating a sense of commonness, and even that can be helpful. If you're holding a council meeting, make sure that those council members participating as best you can have a curious attitude and not one of judgment. And so we'll let you work through those slides when we make them available. The other thing is notices and minutes. It's really important, for instance, when you're providing proxies to people, that they're neutral proxies. You're not creating a situation where you're requiring them to vote in a certain way or look at certain things in a certain way. Notices and materials, proxies should not be used as part of a battle for people to make a decision in a certain way. We talked about using a neutral third party as a chairperson. It certainly creates a situation where emotionally laden issues can be dealt with in a professional manner. It's certainly helpful when the chairperson is really interested in process and interested in everybody getting to speak and dealing with that, because that is sometimes enough to deal with. It can create a situation where you may not have the outbursts, disruptions, and disorderly meetings that you've had in the past. And the person may also be able to deal with safety concerns in an appropriate way and deal with imbalance of power during the meeting. Is security required? If you're asking the question, if you're concerned about security being required, the answer is you probably should look into it. I've definitely been to general meetings where I have insisted on security being there. And so the question then becomes, what are their instructions? What's going to happen? Hopefully you have security there, um, just to put forward to the participants that this is a concern, that it's being treated seriously. And I have seen it de-escalate many situations when there is a presence there whereby they are there solely for that purpose. I've also not been shy about calling police at times. If there's threats or acts of violence, take them seriously. Things can escalate. If there's intimidation, if there's criminal harassment, the safety of participants is the utmost concern. And you may, in this day and age, it could be a reason to hold meetings by electronic means. Do you have thoughts about the security aspect and the calling police aspect, Tony?
Well, we have all of our staff have certainly been at meetings where the police have had to have been called, where there have been assaults, conflicts, and we've had individuals where it looked like the vote was not going to go the way they wanted, who pulled the fire alarms to force the meeting to adjourn. We've had arson attempts at meetings. In just about anything is possible when you're dealing with in-person meetings. We've even had one meeting over the last year where someone tried to hack our Zoom account in the process of a meeting ongoing. So, anything is possible. If there is at all a security concern, make sure it might be worth having a security guard present, and record the meeting in person, online, whatever it is, record the meeting. It will check people's behaviors.
And I think the concern that I see for stratas is you kind of get used to the behavior in your complex, even if it is not a normal behavior, even if it is something that you should not put up with. And so, for instance, I refused to go to a general meeting once, and the council president phoned me the next day and said, that meeting went pretty well. You didn't really have much to be concerned about. But in explaining what happened, he did mention that he got hit in the back, hit from behind from a lady when he's in the parking lot, right? And so I think what happens is when you live in that situation, we all become desensitized to what we live with on a daily basis. But these meetings can really create a situation where there is a heightened sense of, people being angry, people feeling that they need to do something. And it can, fueled by alcohol and whatever else, can be a situation where you need either security or police/RCMP. Again, we cannot control others, but we can change the tone sometimes by using active listening, measured empathy, using problem-solving techniques, maybe doing something that's a bit of a surprise at a meeting, a cool down period, asking for a covenant to engage respectfully from meeting participants, letting them know what the expectations are at the beginning, educating council members on communication skills to use when they're in these challenging roles. And I would recommend for strata managers and council members that they might benefit from some mediation training in figuring out how to deal with disputes. Contacting a lawyer is a good thing to do. It's better to do if there's not a crisis already, but it could be that you're in crisis mode and you need to then avail yourselves of that ability. It may create a situation where you can correct misunderstandings, execute a plan of of how you're going to go about bylaw enforcement, how you're going to deal with a crisis, to find reasonable goals and expectations, including council's expectations of their obligations, and deal with documents in the context of the law, and hopefully moving through the stages of conflict, including because we want to avoid continually being in the escalation phase. I mentioned mediation. It's not used as much as I believe it should be in strata. A mediator is an unbiased third party trained in facilitating discussion, brainstorming, creating a productive environment. In fact, when I go to meetings where there are very experienced chairs, they're using a lot of the techniques a mediator would use. In mediation, parties can reach an agreement that they would not necessarily be able to obtain in arbitration, tribunal, court. Anything that's legally enforceable would go. And that is not something that necessarily is offered through a judge or the Civil Resolution Tribunal. And oftentimes we do see these disputes go to the Civil Resolution Tribunal or go to a judge, but that wouldn't be something that we have the focus and time to deal with today. We've gone a little longer than we'd hoped to, Tony, and went a little bit longer into people's lunch hour than we hoped, but I think we've had a good discussion and we're still under the hour time frame.
We're good, Elaine. We're good. Thanks. So I think, people are really reluctant to file complaints because the repercussions are often not worth it. This is your home. You have to look at people when you come home at the end of the day and be in the same elevator as them. And when the conflict arises, it makes it very uncomfortable. And for individuals or for strata council members who have been through a real conflict with someone, it just takes away the enjoyment of their home. And so, we deal with that every day with members who are trying to struggle through a conflict, a complaint. But, I think you turn the other side of it around, we would see a lot fewer complaints if strata corporations actively funded their budgets and their resources and their long-term planning. And we didn't have all the crises that we have. We wouldn't have people having to go to court because the roof has been leaking for 6 months or a year and the strata won't repair it. That we won't have the constant sewer backups in the building or the elevator that's been down for 6 months and nobody's been dealing with it, even though, it's a 35-year-old elevator that was long overdue for a major overhaul. And strata corporations are really a community. They're an extended family, and all families tend to get in conflict and fight about the same thing, which is money or the lack of money, right? And so how do you get strata corporations to transform that behavior into looking at those things that are big risks? I think one of the most unfortunate things is when individuals are targeted by councils, they're identified as this is a problem person or a trouble person, or we don't like this person. And then a major event comes up and it just simply explodes into something that much greater because these strata councils will do things like block an insurance claim. It's they don't have the right to do it. People are named insureds. They're entitled to that insurance. They pay for that insurance. But now, on top of not getting proper insurance claim file, we've created so much greater of a complaint that's on the go here. So I think
Tony, your
Daryl.
comments about decision paralysis, I think, are really important because when you talk about not moving forward with repairs, I think sometimes that's a concern where council's trying to please everyone and basically does nothing. So there may be people that don't want to pay, not in a position to pay, versus the real obligation under the strata to repair and maintain to a reasonable level. And so you have decision paralysis where perhaps the strata does have options to move ahead with repair. Maybe they could go to court. Maybe there has been a vote that failed by 3/4 vote, but it would have passed by majority vote of the owners. Maybe they could move forward, but instead they don't. And I think that exacerbates things.
Yeah, no, you're absolutely right. I was going to say I managed most, I think pretty much all of the Q&A questions, but Daryl's been doing the chat. So Daryl, did you
Yeah.
have something that we might have missed?
Not really. I think you covered off most of what was in the chat. I just wanted to say one of the things that we've done in my own strata is actively encourage participation at council meetings by having owners attend. It makes everyone a little more aware of what they're saying and doing. So when you can do that, council members tend to behave better, and so do owners. And then really staying constantly on top of owners to participate in the democracy. So come to the general meetings and make sure that if you are going to issue your proxy, it's someone that you trust. Really promoting that as part of the being an active community can help offset conflict, I think.
Yeah. Elaine, you were actually suggested, I think, at one point, I totally agree, Daryl. You suggested at one point that council could have somebody chair a hearing. Was that correct?
It might have been correct because I might have used the wrong phrase for what I was thinking. So I think that under the Strata Property Act and looking at council meetings, because hearings are at council meetings, that the council cannot have somebody else, just like bylaw enforcement, take that away from them. But I wonder if you could have somebody there skilled in facilitation, assisting,
Yeah.
particularly if all the participants agreed.
No, exactly.
Yeah.
Yeah. No, there are strata councils who abdicate their role, the role of chairperson, to other parties or property managers. It's not impossible, but they really should amend their bylaws to ensure that they're facilitating that properly. But with respects to hearings, given the fact that the hearing must be heard by council, it doesn't prohibit a chairperson, but I would be looking at your bylaws to see how to facilitate that a little more efficiently.
And then there would be the concern that that person is overstepping the bounds of how they are participating in the meeting. So are they participating in the meeting from a procedural and solely procedural basis, and has that been agreed upon by those participating? Or are they moving towards a decision-making function or assistance with a decision-making function? And how is that going to be perceived? Given the Strata Property Act has very few duties that the council cannot have another entity do, but obviously hearings and bylaw decisions are one of them. And one of the things that you've brought up to me, Tony, I believe, is the concept that sometimes councils they want to give duties to individual council members to sort of break things up. And sometimes they have appointed a council member as the bylaw enforcement person.
Yeah, we talked about that earlier. It's just a bad practice all around. The other side of that is that this belief that before any action is taken, there has to be a council meeting. Well, if you get a complaint, you can't do anything as a council member until you've gathered all the evidence and all the information. So a notice of complaint is not a penalty. You're not filing any fines. It may go away. It's all done. There is absolutely nothing preventing a policy within a strata where the property manager or the president council, if we've received a notice of complaint, please send a copy of that notice to the other party so we can prepare for what's coming. You're going to have to do that anyhow. What you need to do is council must make decisions on how that bylaw is being enforced.
So you're saying that you could, for instance, at the first council meeting after an AGM, put that in your series of motions that you're going to, the strata manager may send out bylaw letters with respect to investigations and so on, and may send out those notices.
And yeah, because nothing is occurring. There's no enforcement. There's no application of fines, penalties. It can very quickly resolve issues. It may be a misunderstanding that gets resolved. And if more information is needed, you're going to need the time in advance of a council meeting anyhow to gather that information. So it's a courtesy more than anything. It's administrative. No action is being taken. So, to streamline your process, it helps the outcomes significantly.
I did notice a question in the chat about where you get mediation training. And so there's a couple different places or a few different places. The Justice Institute may or may not still provide mediation training. I know their program was changing at some stage not that long ago, but there's also Mediate BC, an organization that I belong to. There's also ADR BC that has, those types of mediation programs. And so those are three places that I would look at with respect to mediation training.
That's superb, Elaine. We're right on 1 o'clock. So that's just great. Thank you.
Well, thank you so much, and thank Tony, Daryl, and all of the people that spent their lunch with us. It's amazing.
Yeah, we ended up with at one point just over 200 people. It was wonderful. The presentation will be sent out. Donna will be sending out the PowerPoint, and we will be posting the recording as well on our YouTube channel, which we do for all of our webinars. So if you want to view it again, you're more than welcome. Please do. And if you have additional questions, please feel free to contact any one of us back again. So thanks, Elaine, and have a great day.
Thank you so much.